Calling the next matter, the Gilead Sciences case. Please come forward. And we're pleased to welcome on this case Justice Desautel from the First District Court of Appeal. Go ahead. Thank you.
Good morning, Your Honors. May it please the Court. Josh Rosencrans representing Gilead. Your Honors, our briefs fully lay out why this Court has been right all the times that it has said that if you sue a manufacturer for defects that caused an injury, you have to prove for injuries caused by a manufacturer's product, you have to prove a defect. I'd like to spend most of my time today on why this Court should reject the specific duty that the Court of Appeal recognized here. And I begin with a point that no one has ever disputed. No case has ever suggested, much less held, that a manufacturer who markets a product that is entirely defect-free has to develop and market an alternative product that is safer for some, especially in the pharmaceutical context. Recognizing that duty would have devastating impacts for public welfare and benefit no one. Let me just describe the social costs. The public health will suffer if juries are allowed to sit as ad hoc development boards deciding which of multiple development routes a company should have taken, sometimes decades before, in hindsight. I'll mention four basic consequences. First, this is the only duty in the history of tort law where a decision to bring a safer product to market actually creates a new class of plaintiffs who can say, if only you had come out with that product earlier, it would have benefited me. This causes exactly the problem that Brown recognized. Innovators will be deterred from bringing improvements to market at all. Second, the duty will force manufacturers to devote scarce resources to addressing side effects from existing products that are already reasonably safe, even if that means sacrificing the far greater interests of a far larger population of plaintiffs who would benefit vastly more from the path that is the alternative path. Here, the path Gilead took was to follow the FDA's plea for a single tablet regimen, which lowered death rates for the far larger population of millions. Third, every choice to go down one development path condemns the manufacturer to a world where there is a new plaintiff class for the path not taken. If Gilead had developed TAF instead of that single tablet regimen, hundreds of thousands would have sued saying, my loved one would have survived if only you would come out with TDF, with a TDF-based single pill. It's an untenable damned if you do, damned if you don't regime. And fourth, under this regime, learning a little bit of information about the safety profile of a backup medicine condemns the manufacturer to push forward that alternative. So innovators are going to have to limit the information they gather once they think they have a good lead candidate, slowing the development of better medicines. This, again, is
Counsel, can I ask you a question about that? I know that you dispute some of the plaintiff's factual assertions, and you dispute what level of knowledge, if any, your client had. Let's say, and this is just a hypothetical, let's say that we were later in the development process after, say, stage 3 or phase 3 trials, if plaintiffs could show that a drug maker delayed the release of a drug, in this case TAF, with full knowledge of the potential harm, and the sole purpose for the delay was to increase profit, do you think that they would have a potential cause of action? I'm trying to figure out the scope of the exemption you're urging here.
Sure. So let me just preface this by saying that I struggle with the hypothetical because
That doesn't surprise me.
no,
Okay.
yes, with the premise embedded in the hypothetical, because plaintiffs have never, nor have any of their amici, have ever explained why in the world a pharmaceutical manufacturer would do that. Their whole patent extension concept is just flatly false, not just on the facts of this case, but how things work in real life. And I can explain that a bit more, but let me answer your question directly. I think there might well be a duty. What you've just described there, Your Honor, is an alternative, a feasible alternative to TAF. I think the way you've described it, that is to TDF. The court of in a feasible alternative is a factor in determining whether you can go forward with a defect claim. In other words, it's a factor in determining whether there is a defect. Now, the Court of Appeal asked the plaintiffs this question, and the plaintiffs emphatically rejected any notion of proceeding on that theory of a feasible alternative that was safer. I'll also say that so many of these hypotheticals describe kind of outrageous, egregious, intentional conduct that doesn't really sound like the basis for a tort. It sounds like the basis for actions that are directed by regulatory authorities, which would also defer companies.
I want to make sure I understand your answer, because we write on a big page, so to speak, so whatever we say won't affect just this case. So one can imagine a different case with highly problematic deposition testimony or internal documents. Yes, we know this alternative drug is safer, but it's just too expensive to develop, so let's just stick with the other one, and if people die, so be it. I understand the core of your answer to be that would be highly relevant in proving that the currently marketed drug, the first drug, was defective, but not as a basis for a claim that the putative marketed drug could create a cause of action.
Sure, you are. I mean, correct. Which is why this court doesn't have to create a new duty. That concept is embedded into the old duty. And let me just underscore that how it works in that context is, so many of these hypotheticals are a little, counterfactual, the way things work in real life, but are a concept where you've got a product, a medicine, you know it is equally effective. You also know that it is safer for everyone. If it's equally effective and safer for everyone, then yes, that's an alternative that needs to be baked into the defect analysis. That is counterfactual, of course, to the TDF-TAF concept or situation, because TAF is only safer for a very small proportion of the population. But let me just go to underscore the extraordinary scope of this duty. And I think the facts of this case really demonstrate in real life how this duty could play out. First, the benefits of TDF for millions of consumers, to quote the Court of Appeal, vastly exceed the product's risks. That's at page 32 of the opinion. It has saved millions of lives. Now, to this day, doctors prefer TDF to TAF. TDF represents 90% of tenofovir sales across the world. Yet plaintiffs claim that Gilead should be liable for injuries associated with the known side effects of TDF based on the theory that Gilead made the wrong decision of which path to pursue 20 years ago in a highly fast-paced scenario where the knowledge was moving very quickly. Second, plaintiffs talk about TAF as safer than TDF, but as I was saying earlier, it is not safer than TDF for everyone. The two side effects here manifest themselves in 1 in 50,000 and 1 in 1,000 patients, respectively. Some doctors prescribe TDF because they believe TDF is the safer medication for that patient. Third, the path that Gilead took instead, at the urging of the FDA and the patient community, addressed a far greater patient need, as I was saying earlier. What Gilead did was to double down on TDF as a basis for achieving the holy grail, a life-saving combination that put all of the drugs in a single pill to be taken one a day. Without that single tablet regimen, people were dying because failing to follow the complex protocols made people miss their drugs, and those drugs then end up creating resistant strains of the virus.
Counsel, all of these seem like very powerful arguments potentially for why ultimately there maybe would not be liability. But why are they relevant in terms of whether your client should be exempted from the general duty of care?
Well, so, Your Honor, because
I want to separate those two, the duty versus liability.
Correct. Because when you go back to the social costs that I was describing earlier, those social costs depend upon a calculation that, let's say in this scenario, was done in 2004, 20 years before any lawsuits. You have to bake in those costs at the time at which you are making those decisions, and you can't reliably gauge what a jury is going to do with the hindsight benefit that they will have years down the road. So every one of the social costs will attach to that decision that is made on the front lines. I would also underscore that on the other side of the ledger, I would urge this court not to create a duty with such grave social costs without the clearest real-world evidence that there is a problem to solve with this duty. What problem are we trying to solve for here? In the real world, are pharmaceutical manufacturers actually withholding safer products from the market in the interest of making more money? Plaintiffs say twice in their brief, that is rare. That's at pages 20 and 48. We say it never occurs, including in this case. Either way, a problem that arises between rarely and never should not be a basis for bringing on these sort of social costs by creating a new duty. Patients are already protected by a duty to make sure that their products are reasonably safe. They're doubly protected by an FDA that makes sure that they are putting the pharmaceutical manufacturer through its paces and making sure through phase 3 studies that it is in fact safe, and they are triply protected by having a doctor interposed between the medicine and the patient, making patient-specific judgments. I said
Mr.
earlier,
Rosencrantz, could you address what existing systems are in place other than the tort system that help incentivize innovation that makes existing drugs safer?
So systems that incentivize innovation. So the main system that incentivizes innovation is when a pharmaceutical company sees a need in the market, as happened in 2010 here with TAF. They respond to that need. They get a bigger market, a bigger proportion of the market, because they move their own patients to that new and safer medication, and they acquire new patients. That is what plaintiffs have seized upon the word cannibalization, but cannibalization is something that pharmaceutical companies actually want to do. The second is, there are all these hypotheticals about mustache-twirling evil people in the boardroom trying to squeeze out every penny of profit to the detriment of patients. If you actually have a company that is making judgments like that, there are regulatory agencies that can step in, as has happened in other contexts. There are also opportunities for either competitors or plaintiffs to bring UCL claims. But a negligence claim is really not the sort of thing that addresses even the problem that everyone agrees is at best rare.
There are two potential paths if we rule in your favor. One could be that we agree with your argument that there are these established principles of product liability law that govern, and that there is no liability absent a product defect. Or application of the Rowland factors, some type of general duty exists, and there should be an exception under Rowland. From your perspective, does it make any difference which path is taken, or what are the impacts of taking one approach versus the other?
Let me make sure I'm getting your first path correctly. So they're sort of like nesting eggs. The first argument which we've made, but I haven't argued this morning, is that there is a defect requirement, plain and simple. I think you're asking about two variations of the argument that I am making. One variation is, no, we're not going to recognize this new duty. It's in derogation of the common law, and we're sticking with the common law. Path B is, there is this general duty out there. It's a general duty of ordinary care, and one needs to justify an exception. My answer to you, Your Honor, is it really doesn't matter that much as between 2A and 2B. It's really just a matter of who bears the burden of persuading this court which of the, whether to adopt the duty or not to adopt the duty.
Can you give us a little bit of your thinking about how we should think about it if it was a 2B, I think you said, Rowland argument?
Yes, Your Honor. You would think about it exactly the way that, that I've been describing it. You would look at not just the Rowland factors, but you would start by asking yourself, what are the rationales for the previous common law rule? Was the common law rule good enough to protect folks, or does it need to be departed from? But then I would encourage the court to start where I started. What are the social costs of proceeding with this duty, even in the exception route? Are there social costs? I mentioned 4 social costs. Then the court can evaluate the other factors, such as foreseeability of the harm and the consequences. In particular, in a world where this court has no evidence that anyone is actually making decisions like this purely from the perspective of profit, are you actually benefiting anyone by adopting a duty with all of these social costs when the duty actually isn't going to affect anything? And then you would go down the other Rowland factors accordingly. Can
I just interrupt to clarify?
Yeah,
Are you abandoning your defect argument?
No, not at all, Your Honor. Okay. I am happy to answer any questions on the defect. I'm sorry, it was over here. Sorry. I'm happy to answer any questions on the defect requirement, and I would encourage the court to adopt that as a rule. I just thought the briefs fully spell out the ins and outs of whether this court has ever actually recognized a defectless claim, and I thought the time was better spent focusing on the specific duty that was recognized.
Let me, unless my colleague has a question on it, I do have one question about the line between defect versus conduct, and you urged us to draw this bright line at requiring proof of a defect in order to move forward. And I think it's harder to distinguish between the two. And I'm thinking, for example, about some of the opioid litigation that has happened. Now, much of that has resulted in settlement, and there's all sorts of different types of claims, but I know that at least one court, the Rhode Island court, allowed the claims to survive summary judgment, finding that the drug manufacturer had a general duty, had various duties of care, including a duty to exercise reasonable care not to cause foreseeable harm to others. So I think it's a little bit difficult, and I'd love to hear more from you about this line between the product being defective versus the conduct of the manufacturer.
Well, Your Honor, so I think that it doesn't make a lot of sense to be saying, oh, negligence focuses on conduct and strict liability focuses on the product. In all circumstances, and this court recognized this in Merrill, when you're in the world of negligence, you are talking about whether the manufacturer should have behaved differently. In here, we're talking about designing the product. You're still talking about the product. And that was the lesson that Merrill drew, that you can't simply recast something by saying, oh, we're not talking about the product, we're talking about the conduct, which yielded the same injury. I did want to make one last point, which I had promised that I would make about this patent extension concept. Plaintiffs build their narrative around the view that state law needs to intervene to fix a broken patent system which creates perverse incentives under Congress's patent scheme. That is a false portrayal of patent law and is a false portrayal of the facts of this case. Plaintiffs and their amici, I was saying earlier, have filed 13 briefs between the Court of Appeal and this court. Not a single one has ever explained how the patent system would ever incentivize a pharmaceutical manufacturer to delay marketing a medicine that it knows is better or safer. More specifically, they've never even suggested that Gilead actually garnered any patent benefit from stopping TAF development when it did in 2004. No rational pharmaceutical manufacturer withholds a great new medicine in the hopes that a decade or more down the line, they will have a longer patent benefit. And they don't for two reasons. And this goes to the question you were asking, Justice Kruger. First, patent terms have absolutely nothing to do with when you go to market. A patent term is based upon the date on which you file your patent application. Once you file that application, the patent clock starts ticking, and you are losing patent term and potential revenues for every day that you delay marketing the medicine. And second, there is no way that a manufacturer can predictably claim to understand or know the effect of a delay on the life of a patent of a family of medicines more than a decade later. There are too many unknowns, too many things that can happen, including new patents coming online. This case illustrates these points. Plaintiffs posit that Gilead chose to stop TAF development in 2004 because it was worried about losing its monopoly on TDF in 13 years later in 2017, but TAF would have 4 years more patent term. It would expire in 2021. But TAF would have had those extra 4 years, regardless of when we went to market with TAF, because going to market does not affect the patent term. Besides, that was not even close to what happened. As it turned out, TDF-containing medicines are protected today, and they are protected through 2033 with new patents that have come online since that 2004 decision point.
Counsel, I wanted to follow up on a point you made a moment ago. You said that stifling of innovation happens rarely, if never, and you explained some about why you believe that to be the case. Given that that's such a rarity, why should we consider giving your client a categorical exemption to the general duty of care? And it's important, again, I think you're asking for an exemption to the general duty of care versus asking the court to create a new duty. I think it's important that we be precise about what's happening.
Well, so we believe we are asking the court not to create a new duty. Plaintiffs believe they are asking the court to carve out an exception. As I was saying earlier,
well, if we're talking about I think I forget what letter
2B,
it was. 2B, yes. The Roland factors.
Right. So I think the question, if I may answer.
Yes, thank you.
The question you are asking, Your Honor, is if it never happens, why should you worry about it? And the answer is, the first few minutes of my oral argument, all of those social costs will happen out of fear that a jury will get the judgment wrong in hindsight here 20 years later when they have an injured plaintiff before them. It was exactly the concern that this court had in Brown.
Thank you, counsel. You'll have 5 minutes in
Thank you.
rebuttal.
Good morning, Your Honors. Your Honors, the bedrock of California's negligence doctrine lies in Civil Code Section 1714 and the principle that everyone is responsible for their failure to use reasonable care in their activities that causes injury to another. The negligence alleged here concerns that of Gilead, a pharmaceutical company that held the exclusive license to research, develop, and market tenofovir-based compounds for the treatment of HIV. While in late 2002, Gilead laid out a detailed timeline to bring TAF to market in October 2006, Gilead soon after made the strategic decision to delay the commercialization of TAF for nearly a decade, solely to maximize profits and exploit its patent exclusivity. And Gilead was willing to accept the suffering of tens of thousands of patients with HIV, forced to endure a drug that was destroying their kidneys and breaking their bones, all so that Gilead could make more money, $27 billion more to be exact. And while Gilead refuses to engage in a Rowland analysis, the public policy of this state, in fact, does not warrant a blanket immunity for a drug manufacturer's decision to place profits over patient safety.
Can you articulate just in a sentence, how would you describe the duty that is at stake?
Sure. I think the court's issue statement in this case nicely applies the duty of 1714 to the decision that we allege is negligent here. And that is, a drug manufacturer owes a duty of reasonable care to users of a drug it is currently selling, which is not alleged to be defective, when making decisions about the commercialization of an allegedly safer and at least equally effective alternative drug.
When making decisions about, that's pretty open-ended. Is there a way that you can add more precision? Sort of what is the operative verb?
I think it's the let me back up if that's okay with Your Honor. When we look at the framework of 1714, and we see that in this court's decision in Cabral, in Kusiamba, in Kessner, we begin with the statement in 1714 that we all have to act reasonably to protect others that we've created a risk from. So as applied to the facts here, the decision that we claim was negligent was that decision to press pause on the commercialization. And that's a word that Gilead uses in that late 2002 portfolio of when they were going to launch TAF on the U.S. market for October 2006, as well as in the April 2003 memos, when they decide, despite its safety profile, we are going to hold it until 2010 to correspond with the expiration of TDF.
So I understand. I want to understand a little bit better the theory under which the defendant created a risk. I understand the view that it actually created a risk of harm. I understand the view that it actually inflicted harm because your clients experienced very adverse side effects from the product that they were actually sold by the defendant. But you are not arguing that that product was defective on its own. In what way can it be said that the taking of that non-defective product created a risk of harm, not just created harm, that created an affirmative obligation to mitigate that harm once created, as opposed to having a pre-existing medical condition that required pharmaceutical intervention?
I understand. And I think the court's really highlighting the source of the duty because it is the relationship between these plaintiffs and Gilead. And so Gilead, as the court pointed out, is selling a product, TDF, that is making them sick. And I think an important narrowness of the duty that we have at issue is we are not claiming, as my friend on the other side said, that this is a duty to make better drugs in general, for the treatment of HIV. This is not, oh, is there a safer drug to treat the illness, right, HIV? The injury is from TDF itself.
Why not plead it that way?
I'm sorry?
Why not plead and argue the case that way, that the TDF, the first drug that was marketed, was defective? I mean, that's the argument you're making here, but that's not the argument in the complaint.
Well, the argument is not that TDF is defective. And the argument is that TDF in itself, when we look at the design of TDF as compared to itself with the benefits and the risks, which is inherent in a design defect claim, that is cabined to the formula of TDF. Our claim is that knowing that they have a product that is making people sick, they have the duty to act reasonably in making commercialization decisions about alternative products.
So do you have to plead and ultimately prove that they knew that TAF was safer and equally effective to TDF?
Well, I think the knowledge element, as is true in all negligence cases, comes into the analysis of breach and what the circumstances are that support your claim that they should have done better. So I think when you look at whether or not they knew they had a safe, if there was not a safer alternative, there is no negligence. What is the harm, right? That is a part of, well, what are the circumstances that form the breach?
And so obviously you have to prove breach in order to prevail, so presumably you'll have to prove knowledge. Knowledge as of what time? As of when it was first developed in the lab, animal testing, phase 1, phase 2, phase 3? When did they have to know?
I think, again, when we're looking at the negligence claim, we're looking at acting reasonably. And here, the product was developed. They had spent years developing TAF, and it was in late December 2002, they made a detailed timeline of getting TAF through the rest of the clinical studies and on the market, approved by the FDA by October 2006. So to answer the court's question, I think it is here and under our facts, that decision to delay TAF based on their own timeline was the moment, and in their memos, they are recognizing that TAF is a safer and equally alternative product. And that decision, we say, needs to be reasonable.
But why isn't it sufficient if the core of the claim is that they knew that they had a safer, equally effective product? Why doesn't that go to whether or not the product they were selling is defective? That's usually, sort of a critical element of a design defect claim.
Well, I think when you look at the negligent design defect claim, right, which, again, pharmaceutical drugs, we don't have that because under Brown, under Brown we don't have strict liability design defect, and under preemption we don't have negligence design defect. But when you look at a design defect claim, you are looking at the formula itself and its risk and benefits for what it's serving to do. So here, when you're looking at TDF, you're looking at what are the risks and benefits at treating HIV, and specifically whether that drug was itself defective. Our claim about the need and the duty to act reasonably in making commercialization decisions about alternative products does not depend on the design or the risk and benefits of TDF as it applies to serving its need, which is to treat HIV. Right? Our claim is that you had a duty to act reasonably, and I want to highlight one point before we go too far.
Reasonably to do what? And when?
Yes.
So you have a disease, I have a product, you're going to die. I can stop that. Now, if I stop you from dying from the disease you have, might affect your kidneys. And bad kidneys could kill you too. But you won't live long enough to die of bad kidneys if you don't take my drug that will cure your disease. At what point do we say, because they don't just decide this overnight, nor does it happen for free. So at what point do we say, because you didn't take a different developmental path, when we say you should have, you're negligent and you owe huge damages because you could have done it differently. Even though, by the way, you cured my disease.
Well, if I can take Your Honor's hypo, I think that that shows why this is not a design defect claim. We're not claiming that they should have pulled TDF from the market and deprived these users of TDF from the treatment of their disease. That illustrates why TDF is not itself a design defect. But it also, because of the relationship, and I want to highlight, Gilead has exclusive license over Tenofovir. This is a compound no other manufacturer could have made an alternative drug. These powerless plaintiffs were dependent upon Gilead, who had exclusive license over the compound Tenofovir, and to be able to take any other drug that had less side effects. It's not like there's a market for TDF products other than Gilead.
And does that make this category of claims different than other products? Automobiles, for example, other types of products you might think about?
I do think it does, and I think it's exactly the reasoning in Brown, which my friend on the other side said at the conclusion of his argument supports his position. I actually think that when you look at Brown excluded drugs, pharmaceuticals, from strict liability design defect. And it did that because it recognized the public needs access. We need access to medication for exactly the court's point, that we have people dying from diseases, we need to get them access to the product. And here,
but doesn't your argument result in a chilling effect for innovation for other drugs if the manufacturers fear liability and as a result are spending their time when there's already a drug that could assist somebody developing or commercializing an alternative version of that same drug?
Well, I think that the crippling of innovation is this it's an echo that we've heard by drug companies. It was indeed one of the arguments that they advanced in Brown to say, hey, please give us this immunity for strict liability design defect. But you look at what happened, and Brown specifically says in footnote 12, we preserve negligence claims. And you look what happened here, the opposite. It was they withheld access to medication that we desperately needed for financial benefit.
But when you say they withheld access, I mean, I guess a couple questions about the basic facts here. That they had just done, I guess, a combined phase 1, phase 2 trial here, no phase 3, right?
Yes.
And phase 3, the purpose of phase 3 is to extend testing to a far broader patient population to make sure it's safe and effective, right? Mm-hmm. So what is and am I correct that the combined phase 1, phase 2 here would have been, I don't know, 20 or 30 patients, something like that? It's a limited sample. That's the nature of phase 1, phase 2, right?
Yes.
So your claim is that they had a duty based on testing 20 patients in phase 1 without any phase 3 trials to what? To conduct their breach was that they didn't conduct phase 3 trials?
Their breach was to act reasonably. They had a duty to act reasonably, and I want to highlight what the court's talking about. When you go to phase 3, which the argument on the other side began with this idea that he was asked, well, if we limit the duty to phase 3, at that point, and he said, well, no manufacturer would go through phase 3 and not market the product. And I think that shows why the reasonableness at this stage, before phase 3, right? Phase 3, they've already spent all the money. They've already made the plan. They are on the eve or the cusp of FDA approval. So why would they pull it at that moment? They wouldn't. But the negligence and the duty to act reasonably occurs here, where they have the timeline in place. They knew they were going to do phase 3 back in January 2004, according to the timeline that they had in late 2002. And they chose not to because they looked at the money. They specifically looked at how much money is this going to take away from our profits for TDF, and what if we postpone that and correlate that to the expiration of TDF in 2015, how much money can we make? And that's what the decision.
But I guess, so again, you've repeated several times they had a duty to act reasonably, but I think several of us are trying to understand what that actually means. I guess concern you're hearing, at least for me, is what I'm now hearing is you're saying that a jury could actually, if there was a special verdict form, that one of the relevant questions would be to 12 lay jurors, not the FDA, should Gilead, based upon what they knew from a phase 1 and phase 2 combined trial, continued and proceeded to phase 3? That's the breach?
Well, I think even if we look at Casey 1220 and 1221, which are the negligence instructions for product liability, we see the way that they define it is, did the actor act reasonably, right? Did they act reasonably in whatever it is we're claiming? So we are not saying that necessarily they had to, at that moment of December 2002, put TAF to market, no matter what comes up between then and 2006. We're saying they had a duty to act reasonably.
And what does that mean?
That means that in deciding whether or not to follow through their original plan, they cannot, the decision that they made to place profits over patient safety, the idea that we're going to make so much money if we just push this to 2010. So we're going to decide to press pause on the development that we have and wait it out. And when we look at duty, this court is often reminded that we look at the respective parties and their positions. And we look at a drug company that is, one of the most profitable types of categories of companies in the U.S. And they hold all the cards in the situation. They hold the compound that can make it safer, and they're making the drug that plaintiffs need to have. This isn't a bike.
What if the reason is not related to the desire to maximize profits, but it's instead we have limited resources. We only have so many people who are available to work on innovating new products, and we think that it's important to devote our attention to another project that turns out to be a bad decision. It doesn't pan out. Can a jury determine that is acting unreasonably because a reasonable, sophisticated pharmaceutical actor would understand that their resources were better devoted elsewhere?
Well, I think that's going to come down to the evidence in the case. I think surely a jury could find the opposite and say, you know what, that was reasonable. How they decide to spend their money, what products they want to develop, is within the knowledge of...
I guess I'm just trying to understand. I mean, the focal point of your argument has really been about sort of bad intentions, profits being placed over considerations of patient safety. But I guess I just want to understand, the nature of a negligence claim is not really based on sort of having bad intentions, right? It's just about failure to exercise reasonable care under the circumstances to protect the safety of others. So I just want to understand if the entailment of your argument is that a jury could decide that, yes, a pharmaceutical company acted unreasonably in deciding to pursue a less promising line of inquiry.
Yes, I think a jury could do that, and I think that's why we would have experts that would come in and say, you know what, their decision to pursue this other means, even though it ultimately didn't pan out to be a successful track, was not was reasonable or was not reasonable, right? We have experts like we do in all cases to really explain what those considerations were, what they knew at that moment. And we have all types of cases, negligence cases, where juries are asked to decide complex decisions about business making, allocating resources, et cetera.
But isn't there we walk into that, I'm sorry. No, go ahead. Isn't that where we walk into that trap of hindsight bias? And what is the plan for drug manufacturers and developers? How are they to know how to appropriately proceed?
So I think the hindsight bias, is true for all product defect cases, right? When you have it in normal products liability. So we're always going to have hindsight bias, even in other traditional negligence cases. And I think it's the role of counsel and the evidence and to show at that moment it fell below the standard of care. With respect to kind of the idea that this is a limitless duty or that this duty, that a manufacturer may not know what their duty is. I think we look at this court's decision in Ramirez versus Plow, which says precisely that the standard of care is to act reasonably. And that precise standard of care of acting reasonably given the circumstances has worked for decades, for years, right, in terms of defining negligence. And I want to highlight this court's decision in Cabral, which I think is helpful in this analysis in the duty framework. Cabral was the case where the Ralph's truck driver parked 16 feet off the outermost edge of the freeway. And he parked in dirt and he was eating a snack. So we have the plaintiff's husband was driving, veered off the road, 16 feet, crashed into the back of the truck. And the Court of Appeal, in looking at that case, said, you know what? There's no duty here. We are not going to recognize a duty. He is 16 feet. He is parked. Where would it end, right? What if it's 100 feet up? What if it's, broad daylight? He's got cones. Where is this duty going to end? And this court cited to the Court of Appeal dissent, where it said, the question is not where the duty begins, but where the duty ends. I'm sorry. I said that wrong. The question before the court was, it's not where the duty ends, but where the duty begins. And the idea was the duty begins in 1714. That if you are creating a risk that is hurting someone else, you have a duty to act reasonable in that. And so when you're looking at, oh, well, what about this? Well, what about that? We then turn to the roll-in factors. And we say, okay, is there a duty to carve out a categorical exception? Right? So in that case, was there a duty to carve out people parking on the side of the road? And even the way the court framed the duty was similar to the way we frame the duty here, in the sense that a driver owes a duty to act reasonably when and where they park on the side of a freeway. So if it's 6 inches from the road, if it's 100 feet, those are the facts that form the analysis of breach. And to the extent Gilead desires a categorical exception, then we turn to, okay, does clear public policy support it? And I want to focus
I guess, counsel, I'm listening to your argument, and there are so many, you keep coming back to this term reasonable, which, of course, is the negligence standard. Isn't this a better problem for the legislature to solve?
I think it is absolutely a problem the legislature could address. But the extent that, as this court has noted multiple times, duty exists, and whether or not there's an exception is either one legislatively created or through roll-in.
Yeah, I mean, it's just that this is the nature of this problem, I think, as all realize, is that there is a very wide set of parameters that are going into the calculus, either for this court in whether to recognize a duty, or for a jury in determining whether a company has acted reasonably. And I guess it gives me some pause because although, you've said a number of things that frame the case in a kind of greed versus, public health frame, the fact is that the law does not prevent a company, right, from reaping profits from its innovation. Mm-hmm. And the idea that those profits should now be capped because the company innovated even more and did it even better strikes me as a kind of problem that isn't, that's a public policy issue. In other words, there could be a solution that said legislatively, well, companies are entitled to monopoly profits on certain licenses or patents or innovations for X number of years, and that's exactly the kind of regime we have. And we should limit it in these circumstances or those circumstances. But for a court or a jury to say that, I think that's what you're asking us to do. I think that's an uncomfortable proposition.
Well, I think the opposite is an uncomfortable proposition to the plaintiffs and to the population who are dependent on drug companies, and that is that we are going to insulate them from decisions that affect our health and our life and our, whether our death, right? This is why the justification was in Brown for giving them this special treatment for absolving them from from strict liability design defect. And I think that is kind of the analysis when we look at, okay, does Rowland justify a categorical exception, and or should the legislature step in? And I think that when we're looking at tort and we're looking at the role of tort law in California, we look at We are considering how do we best protect Californians?
What are the follow-on consequences if we rule for you? Wouldn't any drug manufacturer now pull back its innovation efforts with regard to making an existing drug better?
I don't think so, because when you look at the innovation statistics, which we have in our brief as well as detailed in the amicus briefs in our support, you see that even today, the amount that a drug company can make on a blockbuster drug pales in comparison into whatever tort liability they claim they could face.
Counsel, I think over a decade ago, back in 2014, the Pennsylvania Supreme Court had a similar case.
Yes,
Lance versus Wyatt. And they allowed the negligence claims to go forward. So again, that's over a decade ago. Are you aware of any stifling of innovation or runaway train claims after that case?
I'm not aware of that. And I think when we look at the article I believe was cited in our brief, innovation bullying, we can see that
Say that again.
Innovation bullying is the title of the article, and there the author really kind of explored this idea of does litigation really have an effect on innovation? And it came to the conclusion that it didn't. There was a 2014 RAND study that came to the same and said, policymakers should be weary of these claims, whether they actually affect innovation. And I think when you look at the patent law and the idea that there is this patent cliff where then pharmaceuticals go to generics, you can see why pharmaceutical companies would not be deterred, would not be slowed down to innovate, because they want to maximize the time they have a new product on the market. And all we're saying...
Well, that's exactly the point, isn't it? Is because there is that public policy, and that provides a measure of certainty, which manufacturers then factor into their R&D strategy and what they decide to bring to market, because they can project out what their expected revenue will be. But if we subject this to a tort regime, then they are subject to the unpredictability of jury judgments, essentially, or short of that, having to settle, which is kind of an intervention, right, or an overlay, or I don't know what it is. It's an extra layer, right, of uncertainty against the public policy regime that already exists.
Well, but the public policy regime that exists is so broad that if you look at what's happening today, and this is again cited in our briefs, you can see there's little real innovation going on these days. These days, drug companies focus more on the Me Too drugs, right, the drugs to kind of inch out their patents even longer. So I think that the idea that they are already, kind of incentivized to, bring access drugs to patients that need them is failing, right? That's not actually what's happening in real life. And we know that they spend less on research and development, as they spend way more on marketing and advertising than they do on research and development. And that was supported in our papers too. So I think these doomsday predictions about what could happen if we impose tort liability have been the justification for already so much to protecting them that now we have a situation. I don't think anybody can dispute that the conduct we've alleged, assuming we prove it at trial, is morally repugnant, right? The idea that a company is going to look at a drug, and the Court of Appeal posed a hypothetical to my friend on the other side and said, let's make these facts worse. Let's say that there's a memo that asks how many people are going to be hurt how many people's lives will, I think it was 25,000, 5,000 lives will pass, 20,000 will be injured if they don't have TAF. And there's a memo that says, okay, how much money are we going to make? And the memo says $5 billion. And the Gilead says, okay, let's go ahead and delay TAF, and we'll just cover the cost of those injuries. That was in the hypothetical posed at the Court of Appeal. And the counsel on the other side said, yes, even in that situation, there's no duty. And I think that, I understand that we are on the spectrum of reasonableness, and this is an extreme example of a company acting unreasonable. But under Gilead's proposition for the court to carve out an exception, yet another protection for pharmaceutical companies, we're leading that conduct with immunity. We're letting them engage in that conduct solely for profit and at the expense of patients. And I think it defies the justification and reasoning in Brown by this court. And I don't think there's anything in the record that supports such a massive protection where we are going to protect pharmaceutical companies from tort liability that any other defendant would face. So for all of those reasons, and before my time is up, I really want to focus on the posture of this case as well, and that this was brought as a summary judgment on a very limited ground, and Gilead has refused to really engage in the analysis of Rowland. And the only factor that Gilead cites is the social costs, which we dispute. They do not go through the other 6 Rowland factors, which all favor the plaintiffs.
Okay, counsel, your time is up now.
Thank you.
Thank you.
Your Honor, just a few points. First, as several of the justices have noted, plaintiff's theory is extraordinarily expansive. Just to be reasonable is not a standard that manufacturers in any sector can implement, and certainly not in this critically important sector. The Court of Appeal purported to narrow the duty, but it never actually applied guardrails. It just tailored its analysis to the allegations in this case. Now, Justices Evans and Groban both asked about the timing of the knowledge, and I want to underscore that the Court of Appeal did not even limit this duty to actual knowledge. It left that question open. Plaintiffs have left no doubt, both in this argument and in their briefs, that they want to go with a standard of constructive knowledge. The duty would still be problematic, even with a knowledge limitation. In the pharma context, you never know that something is safer, that one drug is safer than an alternative drug and equally effective till you've gone through phase 3 trials. And yes, to Justice Groban's question, it was 20 people who took TAF over 14 days. That is nowhere near what you would need for the phase 3 trials. Justice Groban asked the question, what was the breach? What were they supposed to do? The concrete answer to that question is not behave reasonably. The concrete answer was develop TAF, which would have taken another 5 years and around $100 million. And that is a real chill on innovation if that is what is required in opposition to the other path that was chosen. Plaintiffs say that the product was already developed. Another thing that the Court of Appeals said, although it did not limit it, the duty even to that context, the Court of Appeal used that phrase to describe a scenario in which there was still a necessity, if we're pursuing TAF, to engage in all of those studies and spend that money and the extra time and the human resources that it takes to partner with hospitals and bring in patients. Justice Groban asked a couple of times, what does that mean? And this court has been struggling with precisely what the duty is. That is precisely why the current law favors the defect requirement. It's clear. It's got 100 years of precedent defining it, and juries can implement it. To Justice Liu's question about whether courts and juries or legislators are more appropriate to decide this issue, my colleague on the other side talks about Cabral, a case about parking trucks. This is not about parking trucks. This is about life and death decisions and incentives for drug manufacturers to produce products that will save our lives. Ramirez and Verdugo address this. When you've got an incentive structure that is finely tuned by Congress, you don't want juries making individual determinations that a particular path was the wrong path. I just want to clarify a question that Justice Evans asked me. You had asked whether we're asking for an exemption from a duty. I just want to make it clear. We embrace the duty on a manufacturer with respect to products it sells is a duty to make a non-defective product. What we are resisting is an expansion of that duty. Justice Kruger, you had asked the question earlier about what protections there are from consumers, and I gave you a few answers, but there are multiple protections when someone is behaving in ways that are anti-competitive. You've got regulations, you've got antitrust, you've got fraud, you've got UCL, you've got FDA approval to protect patients, and you've got robust competition. Whenever you have a product that is on the market, the competitors are nipping at your heels with a better product. Of course, you are going to try to continue to innovate as long as the law does not get in the way. And for all of these reasons, Your Honors, this court should reverse.
Thank you to both parties for your arguments here today. The matter is submitted.